So my name is Cliff Willmeng. I live in Lafayette, where I'm a registered nurse out there at the Kaiser Place. And my family and I moved to Colorado in 2009. Really, we came from Chicago, where I had a background in political activism there, mainly around labor rights, rank and file, union issues, that sort of thing. Anybody remember Seattle in 1999 against the World Trade Organization? That was awesome. I was out there for that. I was one of the founding members of the Direct Action Network in Chicago. And so when we moved to Colorado, I had a degree of political activism behind me. But really, I was a brand new father. My daughter was 1 year old at that point. And as an RN in the ER in Chicago, we decided that we couldn't afford to live there, and we wanted to kind of come out to a place where we could be boring suburban type people. I told my wife that we would be leaving a lot of our political activism behind us in Chicago at that point. And I didn't know that I would be moving onto an oil shale. I often joke that our attempt at becoming boring suburbanites we failed miserably at. And we moved to Lafayette basically to raise my daughter, who was 1. We had my son, Charlie. He came along about a year later. And so when we came out to Lafayette, we got a nice little house out there. We did what everybody does when they come to Colorado, which is you try to set up a nice little life for yourself and go snowboarding and entertain yourself and be the best dad that you can be and that sort of thing. It was about 2012 that I realized that in the neighboring town of Erie, there was a big protest of a bunch of mothers there. And I did not realize what was taking place, but apparently what they were protesting was a massive oil and gas well that Encana Energy was developing right next to Red Hawk Elementary School. And I remember this because it was June 2nd, 2012, where I read this in the Hometown Weekly, which is our kind of little small town paper out there on the eastern part of the county. And at the time I said, for one, what's fracking? Because I did not know what fracking was 5 years ago. And for 2, how the hell are we going to stop the oil and gas industry? Because Lafayette, where we live, is right next to Erie. And so that really started my journey down a very major rabbit hole that would eventually introduce myself and a lot of folks to Thomas Linzey. We began these campaigns not only in Lafayette, but ultimately in Boulder County right around that time. So I want to, in about maybe 15 minutes or so, I kind of want to go over some very important components that brings us all here today. For one, where has that fight come from? Well, the last 5 years, what the hell has happened that right now, even in the last week, the Boulder County Commissioners right across the street from us are now starting to move with seriousness about permitting what could become, by their land use department's estimates, up to 1,800 wells in Boulder County. And I want to introduce the major barriers and hurdles that we encountered on the way. How many people here have ever seen The Matrix? All right, we're going to do the best we can today to shove the red pill onto you. All right. So we will tell you, our successes and our failures and what we did not foresee and what we got blindsided by and what we are currently struggling as hard as we can against. I want to talk a little bit about the Lafayette Climate Bill of Rights and Protections that is in a state of flux out there on the eastern part of the county, and then a little bit about where we go from here. And then I'll allow Thomas to follow me up, who will take a broader perspective on all this, because believe it or not, all of our experiences in Lafayette and Boulder County are pretty common to communities across the country. The only changes is that we're not in immediate communication with each other. So back then in 2012, we were all quite naive. Even coming from a political background, I was not aware of the degree by which the system is so completely fixed. And what I mean by that is that, when we responded in Lafayette to this idea of oil and gas development, we did so according to a script that was written by the oil and gas industry and the various politicians that either apologize for it or are completely in favor of oil and gas drilling. And our response was something like this: this is horrible. Why the hell would we want Lafayette to be turned into an oil and gas field? we're going to go to the city council because there's no way they would allow this to take place, right? So we did that with a degree of sincerity. And when we got to the city council, we were told what we were all told all over the country. I'm sorry, this is a state issue. Our hands are tied. We don't like fracking either. It's very concerning to all of us. Go to your state representative, and in the meantime, we'll enact the best regulations possible to make this industry safe for the good people of Lafayette, right? That to me created a bit of an existential crisis within myself because I was not aware that we were totally disenfranchised on the issue of our environment. The environment, it might not be news today, but back in 2012, we did not realize that the environment was a property issue and not a morality issue. We did not realize that the courts were not ruling on the basis of morality. They were ruling on the basis of a set of rules, the bylaws of capitalism, really. And they rule predictably. And we think that we influence them by making a moral appeal to them. And they're very comfortable with that because it produces a regular failed outcome, which the oil and gas industry is very comfortable with. So back there in Lafayette in 2012, we started with a very small group of people. A few of them are here today. And we said, well, we don't want oil and gas drilling in Lafayette because we don't want to negotiate the parts per billion of benzene that our kids are breathing. That sounds insane, and it's kind of a non-starter. So there was a person in our group that said, well, if you're going to fight the oil and gas industry, you need to get in touch with the Community Environmental Legal Defense Fund, which is what we did. And the folks at CELDEF, which is the acronym of it, spoke to us very clearly. And what they did is they helped deconstruct the system for us. Because when we were working under this impression that the system is actually listening to us, we were doing our activism in a reality over here that was totally separate from the objective reality by which the system operates. The system is very comfortable with you being over here. It tells you to go over there. And we were told to go to the city council. We even went to Mike Foote, the very progressive Democratic representative. And you know what Mike Foote told us? Mike Foote told us that nothing passes the Colorado legislature that oil and gas does not want passed, right? And we were told that oil and gas should be cooperated with and collaborated with, and that we could get a better set of instructions from the oil and gas industry. And what we concluded was that's kind of like negotiating terms of surrender, right? And so we determined that was again a non-starter. And so we constructed, with the help of CELDEF, the Community Bill of Rights out there in 2013, which was, to this day, the most audacious and comprehensive ban on fossil fuel development in Colorado history, without a doubt. It's 3 pages long. It has an entire section of rights, including our right to clean air, clean water, our right to local self-government. And so we banned fracking on the basis of that. We also banned all the construction of new oil and gas infrastructure, pipelines, all of that kind of stuff. We banned the disposal of industrial waste, the injection wells that are causing all the earthquakes. So we did all of that. When we entered into that process, we ran up against a political layer of people that argued that this was too radical. All right, that going after the system itself, that going after or negating the rules of the system that said that you can't ban fracking was too radical. They also said that like creating rights for the environment that were independent of it being property was too radical, right? And what we were instructed is that we were to work with the system, but by what we figured out what that meant is that we needed to lower our expectations for the oil and gas industry, and we needed to lower our expectations for what could be achieved in 21st century America, and compromise, right? And we understood that compromise was based on the threat of physical assault on our own lives and kids, right? We didn't even get into the climate at that point. So like when we talk about regulations today and you hear about setbacks, Mike Foote's a big champion of the setbacks now. and you're negotiating with the oil and gas industry the terms by which you are drilled, we did not get into the argument about the best case scenario being that all of the carbon gets pulled out of the strata of the earth and deposited in the atmosphere. The consequences of that we didn't even really bother with. The climate is what I'm talking about, and climate change. So that's the way we were gone after. And it really wasn't the oil and gas industry that created the first major obstacle to victory. It was the kind of progressive layer of the Democratic Party that did that for us. And what they said is that, although, we're all on the same page, you hear that over and over again, what we need to do is go about this in an incremental way, and you're asking too much, and you're being too stubborn about this stuff. And our perspective is if we can't be stubborn about defending our own lives, probably the rest of the stuff isn't worth being stubborn about anyway. So we went ahead with the Community Bill of Rights, and we campaigned for it in Lafayette. And true to form, the progressive Lafayette City Council, 3 weeks before the vote in 2013, took up a measure that broadly condemned the entire amendment, and that condemnation of the Community Bill of Rights passed the Lafayette City Council unanimously. So when people talk about, oh, well, it's Boulder County, they're different there, they would never allow that stuff. The practical reality is, yes, absolutely. And there's a lot of political ties between political ambition and your loyalty to the oil and gas industry out here in Boulder County. So while it's nice and we always talk about solar panels and 100% renewable, the solar panels don't really achieve the intended effect alongside of 1,800 oil and gas wells. At least scientifically they don't. Politically they achieve the right effect, which is to ease your mind about the whole thing. So 3 weeks after the Lafayette City Council condemned the Community Bill of Rights, it passed by a vote of 60% of the Lafayette population, right? Which clearly showed to us that the politicians were somewhat out of touch with the demands of the constituents, right? So they had become, in essence, a bureaucracy, right? They were saying all the nice things that we're all against fracking, but what they were in essence trying to do was suppress the demand that was coming from below, that we had a right to an environment that was sustainable and clean, right? That pattern has not changed over the course of the last 5 years. There was a compounding problem back then too, because the Boulder County, how many people here know that Boulder County has fracked oil and gas wells currently in it? Yeah. Does anybody know when the last time they fracked in Boulder County? What year? It was 2012. 2012, Encana drilled 8 wells in Boulder County open space, right up by Long Beach, right? It was about 3 weeks after Encana lost one of their workers to an explosion. And in between time, one of their representatives, Wendy Weidenbach, actually said, she went on record and she said, Boulder County will be drilled with the same degree of responsibility and safety as we've always drilled. Yes, true story. So not only were we fighting this effort in Lafayette, but we understood that there was, that there was a much bigger fight brewing in Boulder County. Because even if in Lafayette, if we were able to stop drilling in this small town, if we were absolutely ringed with an entire oil field of 1,800 wells, air moves. That's the problem. So we said, we're going to have to go into Boulder County and we're going to have to cause a problem, because it seems like the Boulder County commissioners are telling us a few things. Their hands are tied. We should go to our state representative, and in the meantime, we should be negotiating the best regulations that the state can permit, which again, we felt was a non-starter. So when we came down to Boulder County, what we encountered at that time was a group of people that was working to instill the best regulations that the state would permit. And of course, the oil and gas industry would have to sign off on those, otherwise we would get sued, just the way we all do. And our position was, again, that's a non-starter. We were unable to negotiate with the political layer of folks that didn't want to hear anything other than that Boulder County could be safely regulated. And so we created the first direct action in Boulder County history around oil and gas development. And what we did is we shut down the county commissioners meeting with a mic check, which was made very popular by the Occupy movement a bit earlier. But basically, we took over the county commissioners meeting. We had chants and all this sort of thing. The county commissioners responded by pounding the gavel violently on the podium and telling us to be quiet. We wouldn't be quiet, at which point all of the Boulder County commissioners left the county commission, and a bunch of kids went and assumed their chairs up at the front of the county commission. And so after holding the meeting space for about 20 minutes, I eventually called for a vote on banning fracking altogether in Boulder County, and lo and behold, it passed like unanimously. And so that was the only vote that we've been allowed in Boulder County on what we would actually like. Does anybody here want fracking to come to Boulder County? If any undercover officers, this is the time to acknowledge yourself. So that changed the entire political climate. We were attacked with a whole lot of anger because what we had effectively done is we disrupted the relationship between the people that wanted clean, safe fracking from the commissioners, because the commissioners now had to turn to those people and say, you've clearly lost the steering wheel here. There's a new group of people that is a lot less compliant than you are, and this represents a problem. The Boulder County commissioners went on, they passed their regulations, they tried to, they at one point even voted unanimously to end the moratorium in Boulder County and to start accepting more permits for oil and gas development, at which point we had a mass community meeting right down the street at the Unity Church that was attended by 300 people, where we started to put together campaigns for recall and for direct action and civil disobedience. 3 weeks later, the Boulder County Commissioners reconvened and took a vote to reinstate the moratorium, and that passed unanimously within 3 weeks period of time. They were very gracious about it. They told us that their actions and their vote had absolutely nothing to do with our opinion or our behavior at all, which I thought was telling in itself. But that was it. At that point, we kept elevating the political pressure on the commissioners, and we started to become more emboldened, to be quite direct. We certainly didn't get any more sleep in the last 2 years than we have. Fighting a two-front war in Lafayette and Boulder County has been exhausting to a lot of us. What we have achieved is that we've stopped fracking in Boulder County for 4.5, almost 5 years now, right? So what we've illustrated, which is what you're told you could never actually achieve, being defiant, is that we have stopped the most powerful industry in one of its greatest shale plays in the country, which probably equates to some hundreds of millions of dollars of lost profit. In the process, we have saved billions of dollars from becoming permanently polluted in Boulder County. When we came down to Boulder County and did all of those actions, it produced a degree of political tension within the county that exists today. And if you were at the Boulder County, how many people were at the Boulder County Commissioners meeting this last week, right? And fracking is going to be made safe again, isn't that right? So I looked at their new regulations, and they have like little words on the overhead that they really emphasize cooperation and scrutiny and other words. Lots of nice sounding words that were totally superficial in any meeting, at least from an environmental standpoint. And so that's where they are right now. I don't know if anybody has ever seen this, but this is interesting. This will give you a perspective of why we have come so far, at least in terms of the apologizing for the fracking industry. How many people ever read this? This is called Horizons 360, which is an oil and gas publication, right? And featured within this oil and gas publication, which is a kind of a compendium of voices from the environmental community and politicians and the oil and gas industry. It's an oil and gas publication. This particular piece called Collaborating for a New Energy Future. How many people have ever read that? Does anybody know who wrote it? Elise Jones. Oh, yeah. So Elise Jones wrote this piece in 2011. And her perspective at that point, she was executive director of, she was regional director of League of Conservation Voters, and the executive director of the Colorado Environmental Coalition. It's interesting, isn't it? So way back a long time ago, when none of us knew what the hell was going on, the industry and trusted environmental groups, as well as politicians from both sides of the aisle, got together and they knew that fracking was coming into Colorado and to Boulder County, and they developed a very sophisticated public relations campaign around it because they knew that turning Boulder County into an oil field would be seen as offensive to some people, crazy people like you. And so what they did was they put together a public relations campaign that basically said that oil and gas is a new bridge fuel to a fossil fuel-free world, right? Check it out. It's all, you can read all this stuff. And what they did was they enlisted people like Elise Jones to serve as the mouthpiece for the industry to make people feel that fracking could be done in a responsible way. I don't believe that fracking can be done in a responsible way, and I think that the science kind of backs that, as well as our daily experience of it, at least here in Colorado. The problem that has occurred now is that this is the script that we have been given. The script that we have been given is that we're going to go to our elected officials, we're going to state our moral case. They are going to hear us because they're nice people. They are going to craft regulations that take our concerns into mind. And they are going to create a way that Boulder County can be drilled to smithereens and spare at least our peace of mind, right? Right now, Boulder County ranks as an F in air quality, at least according to the American Lung Association. I don't think I really need to go over all the harms of oil and gas activity for you folks. But as a registered nurse, I know that even the Denver Post admits that that there have been 750,000 cases of childhood asthma directly linked to oil and gas development as of today, right? We get this in the clinics all times. People are having trouble breathing because the air is the worst in the country, among the worst in the country. You'd have to travel to find worse air than in Boulder County right now. And the commissioners are busy trying to end the moratorium. So I'm going to move kind of fast here for the next few minutes because I wanted to give a very good foundation to how we've all been so totally screwed. Because it's very hard to make plans and to strategize if you don't know the topography of the environment that you're actually doing this work in. So when people say, well, we're going to go to the county commissioners and they're going to do us right, or people say, they'd never let fracking in Boulder County. Fracking has already taken place in Boulder County. It's already a fact of life here. You'd have to come out to the eastern part of the county in order to see it. But they're stuck on this script. And our job is to destroy this script. It's not because we're necessarily in favor of chaos. It's not because we're too radical. Most of the people that are working on these issues are mothers, fathers, nurses, teachers, real basic folks that just want to lead a good life and safely. In Lafayette recently, we introduced something called the Climate Bill of Rights and Protections. Is anybody familiar with it here? Has anybody not heard of the Climate Bill of Rights and Protections? Okay, good. So the Climate Bill of Rights and Protections was introduced in Lafayette in January of this year. It follows a similar strategy as the the Community Bill of Rights in that it bans oil and gas drilling in Lafayette as an infringement upon our right to a healthy climate. Again, if you don't have a healthy climate, the rest of your rights become kind of secondary at that point. If there's extinction on the planet taking place, your property rights probably take second base at that point. The interesting thing about the Climate Bill of Rights and Protections is that it was written by a group of people in Lafayette that knew that we could not rely upon the city or the courts or the government to protect us. And we knew that we were going to have to stop appealing to the to the goodwill of those institutions to protect the environment in Lafayette, and that we're going to have to start protecting it directly through the use of nonviolent direct action ourselves. This obviously sent up a shudder wave through the community and through the entire state, because in essence what the Climate Bill of Rights and Protections sought to do was legalize direct action. There's only been a couple communities across the country that have ever achieved this or even sought out to do something like this. One of them was Grant Township, Pennsylvania, which is facing injection wells from the oil and gas industry, and they legalized direct action to protect their right to a clean environment. The Lafayette City Council vacillated wildly on the Climate Bill of Rights and Protections. We never really felt that it would pass for sure, but what we wanted to do was start to create a narrative by which we could start to help people break out of the box of expected and reliable and predictable activism, right? Since December, I think we've had, 5 or 6 direct action trainings out there in the eastern part of the county to teach people in the strategic use of direct action, civil disobedience, how it's been used within the context of larger campaigns for communities to gain power throughout history. I can safely say that we cannot put on direct action trainings fast enough. All of them fill up. I've never seen anything like it in my life. When I survey the people that are at the direct action trainings and I say, how many people here have ever been to a direct action training? It's usually about 20% of the crowd. We've trained 2 Lafayette City councilors in direct action now. One of them is my mom. I don't know if you guys know that. We've trained physicians. One woman actually went up in front of the city council and she said, when everybody's calling us a radical, I just want to let you know I'm not a radical. I teach kindergarten, right? So these are the types of people that are training in direct action to protect the environment here in Colorado, or in Lafayette and in Boulder County now. We believe that the county commissioners are determined to bring fracking in. We are determined to keep fracking out. And that is the conflict that we arrive at here today on this really nice Saturday afternoon. I'm sure we'd all have nicer things to do. But looking forward, this is the way things are likely to play out. The Lafayette City Council achieved a total gutting of the Climate Bill of Rights and Protections. They took the direct action piece out. In other words, they reserved the right to prosecute and arrest anybody that was interfering with oil and gas development in Lafayette. So when you say that you're against fracking, but you want to maintain the police's ability to crack some heads on behalf of the Colorado Oil and Gas Association, we consider that a disconnect. It doesn't really matter because we've told the city council that we're enforcing the principles of that ordinance regardless of whether it passes or not. We don't know for sure, but we are in communication and we are talking right now about creating a new ballot initiative in Lafayette that would be the same way that we passed the Community Bill of Rights in 2016, except for it would be around the Climate Bill of Rights and Protections, and the aim would be to legalize direct action to keep the fossil fuel industry out of Lafayette because we know the courts are not going to do that. There's another problem, of course, here in Boulder County where we are looking down the barrel of these 1,800 wells again. We have submitted a Boulder County Climate Bill of Rights and Protections to the commissioners. They paid it minor lip service in the last couple weeks. We do not believe they will either seriously consider it, let alone vote on it publicly. And so we are now in the position that a lot of civil rights movements in the course of history have found themselves in. The system has failed us entirely. And we do not see any reason to cooperate with our own destruction anymore. And that's just the fact of the matter. So we are continuing with direct action trainings. We may, again, start new ballot initiatives that are far more audacious, not more humble, that's the wrong direction, that are more audacious, that talk about the legitimate and objective preservation of this environment in Boulder County for generations to come. I want to say that we've been joined by Spirit Horse Nation, which is led by Lakota Sioux, Doug Goodfeather, who is in the back here. And so we feel that although the parallels, there are some parallels there and there's some parallels that are not there, we want to declare a state of standing rock here in Boulder County. We mean this. We are ready to go to jail over this. We're ready to get arrested for this. Some people are ready to go to jail long term for this, and some people, even Gustavo Reyna of the Lafayette City Council, said that he was ready to take a bullet before he allows fracking to get into Lafayette. We'll see. Hopefully it won't come to that. So that's kind of where we're here in Boulder County. I want to thank you all for coming. I want to turn it over to Thomas Linzey. I think the task is quite clear. And we want to let you know, and we'll re-emphasize this, that we are having an all-day direct action training here on the 26th. We expect the commissioners to pass the regulations by which fracking will begin as soon as next week. So thank you very much. And let's go from there.
So 6 days ago, I was meeting with the Red Lake Band, the Leech Lake Band, and the White Earth Band of the Ojibwe Chippewa. And it was my pleasure to be able to speak about Lafayette for the training that we did there. The main reason I bring that up is that it was -8 degrees in Minnesota when I was there one night. And so I think I've had a 90-degree swing between there and here. So I have a little bit of a cold. So I apologize for that, but we'll make do. So I wish I could say that the experience of other communities across the United States is different than the experience that you have here. I wish I could say it's just a difference in who you elect. I wish I could say it's just a difference in who's in charge of the policy levers within particular governments, but it's not. It's actually a structural issue, because in these other communities where we work, they run into the same hurdles, and it's because you live under the same system of law. And in fact, the structure of law that keeps you from saying no to certain dangerous things that come into your community, that are proposed for your community, actually is trackable all the way back to the DNA of how this country has been built. So all the way back to the constitutional stuff. It's why when Cliff talks about the first thing that you ran into was not the corporation or the trade association, it's your own system of law that you run into that divests you of the authority to actually say no to certain dangerous things coming into your community. It took us 15 years to get to that conclusion. As a law firm, it took us 15 years to come to that conclusion. And so in the beginning, we didn't come out of the gate, out of law school saying, hey, there's this structural issue, it's systemic. We need some kind of very basic change in this country so that communities have any degree of self-government, because that's what we're talking about. When you say no to a pipeline coming through your community, or say no to fracking, or say no to big box stores or factory farms, we're talking about your right to self-determine, your right of self-government in the place where you live. Because if you don't have that right, then somebody else does. And in many cases, it's the corporations that come in to actually make decisions on your behalf in the communities in which you live. So over 20 years ago, we were created as a law firm, the Community Environmental Legal Defense Fund, to provide free legal services to conservation-oriented community groups. We thought that the answers lie within the current conventional system. That if you wanted to say no to a project, that you had the leeway to do so within the existing system. And so at one point we were representing about 300 citizen community groups across the state of Pennsylvania, which is where we got our start. And those groups all had one common denominator. They were basically neighborhood groups, community organizations, 5 or 6 people that came together that said, we want to stop a toxic waste incinerator that's coming into our community, or a factory farm, or one of these other thousands of different single issue projects that we encounter in these communities every day and every week across the United States. And when those folks would call us to obtain our services, they would say, we don't want this factory farm, or we don't want this frack well, or we don't want this facility in our community, because our definition of sustainability doesn't include a 20,000 head hog factory farm in the middle of our community. And we would say to them, you know, we're with you philosophically. I wouldn't want to live next to a 20,000 head hog factory farm either in my community. But unfortunately, the system of law bans you from prohibiting any legal use. And this is usually where our democracy schools take off, these 3-day trainings that we do, because most people aren't aware that that's law, that that's embedded within the structure of law. But if a facility or a project or a proposal has been permitted by the state or federal government, in other words, it's a legal use, that communities are banned from prohibiting that use. So if something's been deemed to be a legal use, communities in the United States are banned from prohibiting that use. Now, this isn't, Pandora's box that I'm opening up here. You ask a corporate lawyer, you ask an environmental lawyer, they're all in agreement on one thing, which is that is the law in the United States today. And it's been that way for about 150 years, that communities have been constrained from actually banning certain uses that have been permitted by other levels of government. And the reason for that, of course, is that when something's permitted by the other levels of government, it's deemed to be safe. It's deemed to be okay. It's deemed to be permissible. It's deemed to be legal. And so there's no reason for a community to have a veto power over that project because something's already been deemed to be safe and legal by the authorities and the agencies that have resources to look into those things and all that kind of stuff. And so that's been the law for the last 150 years. And we would get phone calls from communities in Pennsylvania asking for help. We had to explain that to them. We'd say, philosophically, we're with you. I wouldn't want that facility in my community either. But unfortunately, in the United States, you're under a system of law in which you can't ban that facility or proposal. And they would say, okay, what do we do next? And we'd say, we're so happy you asked, because we're environmental lawyers and it's what we do. And what environmental lawyers do today, as they did before, was appeal permits. So permits been issued by the state or federal government to the corporation that's putting in the facility. And the job of environmental lawyers is to take the environmental regulations that have been written to govern the issuance of that permit and the permit application itself, which is sometimes thousands of pages long that the corporation submits, and compare the two and figure out what's missing. Gaps, omissions, deficiencies in the permit application that the regulations are required to be in the permit application. Given that 90% of all permits in the United States are not appealed because the communities don't have the resources to actually appeal them, that sometimes just by showing up is enough to win those permit appeals. And so we showed up and we won a bunch of permit appeals. In fact, almost all the ones that we filed, we won. So we had a win-loss record of like 302, something like that. The unfortunate part is folks that have been through the permit appeal process understand is that as soon as we found a gap or omission or deficiency in the permit application, like somebody had signed the wrong place, or the wrong corporate official had signed here, or a bond was given but it wasn't enough, or there was an old macroinvertebrate water study that was 10 years old, should have been 5 years old. Those types of things are what we look for. So we're in front of a judge arguing, Your Honor, under section little 2, little c, little d, little 2, little Roman numeral e, little 2, little c, little d, that the secretary signed the application but not the president, which was required under the regulations. And the judge would say, you're right. And he or she would overturn the permit. The community group would then have a victory party. We'd go back to their house. They'd pat each other on the back and say, the system works. We found a lawyer that could speak somewhat intelligently. We found a judge that listened. We had grounds to bring the permit appeal. And we're not going to get that toxic waste incinerator in our community. Of course, what would happen next, 2 weeks, 3 weeks later, is that the corporations would come back. They'd fill in the gaps, omissions, and deficiencies that we had identified within the permit application. And in fact, we had got to a point where we had some of the lawyers for the largest corporations in the United States, like Chemical Waste Management, for example, who would come up to me afterwards and thank me for identifying the gaps, omissions, and deficiencies in the permit application, because then they could bill more to the corporation to actually fill in those places in the permit application that the corporation had missed. And so after a number of rounds of that, depending on how large the corporation is that you're taking on, I'm simplifying all this down, sometimes it was 6, 7, 10 rounds, that eventually the community group comes back to you and says, Mr. Linzey, we want you to do that jujitsu that you did the first time around and get this permit kicked out. And we had to look back at them and say, we're sorry, there's nothing we can do anymore. Because there's nothing in the regulations anymore that we can use as a lever. There's no gaps, omissions, or deficiencies left anymore. That, in a nutshell, is how environmental law is practiced today. That is environmental law. Some of the nasty little secrets of environmental law, of course, are environmental law is not built to stop anything. It's actually built to make sure that the project causes a little less harm by following those regulatory rules, and in essence, to regulate it so it causes a little less harm. And I think my awakening in many ways through doing these cases came when it seemed that there was a particular constituency, mostly liberals, liberal progressive types, who celebrated our win-loss record. This 302 or whatever we had on paper as a win-loss record, but didn't seem to care that if you went into the communities that we were representing, that there was absolutely no similarity between the communities themselves and the win-loss record that we had on paper, because those communities were getting shellacked. They were getting the toxic waste incinerator, they were getting the factory farm, they were getting the frack job, they were getting whatever project they were attempting to stop, because the permit regulatory system wasn't built to stop those things. And somebody back then said something that two things that resonate with me today. One is that we assumed that we just weren't strong enough, that we just weren't big enough to make the regulatory system work for us, that it was our fault, that we just didn't have the resources, we didn't have the personnel, we didn't have the energy, we didn't have all this other stuff. And then we learned that the monies, and we thought at least we were costing the corporations money, that the corporations had to hire lawyers to come in to fight us in the permit appeal process. It was then that we learned that the monies that the corporations spend on permit defense is tax deductible as a reasonable and necessary business expense under the law. So it's structural. There's a structural thumb on the scale. Meanwhile, the communities themselves had to carry their own financial burden, right? Because when you do file a permit appeal, you got to pay for it. And there's no way to get those monies back unless you can show, some kind of outrageous behavior by the agency, and that's rarely shown. So the thumb is on the scales of what's positive here, what's good, and how the system should function. And the other thing that's a bit deeper, which gets at some of the stuff that Cliff was talking about, is that somebody said back then that the only thing that environmental regulations regulate are environmentalists, because they make us predictable as to how we fight when projects come in, because those regulations were written by the very corporations that ostensibly those regulations are supposed to regulate. And if we think the corporate boys who are actually trying to put projects in are going to build any safety valves in there for the communities to say no to them to come in, we're the insane people. That's insanity. If you think the corporations are going to write rules that voluntarily give power to the communities in which they're siting to physically stop them from coming in, that's nuts. That's crazy, right? It assumes this mythical world in which we live where unicorns are jumping over rainbows. It's just not the world, right? It's just nuts. But that's how environmental law has proceeded for the past 40 years. 40 years, that's how environmental law has been practiced underneath that regulatory structure, assuming that we can make it work for us. That's nuts. It took us 15 years, took us 12 years to figure out that it was nuts because we had hard heads. And we decided to switch gears. And we said to ourselves, if change isn't going to come from the state government or the federal government because they're so tied up and enmeshed with the corporate folks. I mean, a lot of times we talk about, corporations jumping, the people who work in corporations jumping the aisle into the regulatory agencies. And I think we see that a lot with the Trump administration, more so than maybe other administrations. We talk about that as being an issue, the personnel changing, the personnel being kind of the same. But there's even deeper issues there about the purpose of regulatory agencies. What's the purpose of the regulatory agency? And a lot of us think the purpose is to protect health, safety, and welfare. But maybe it's not. Maybe its purpose is to put a insulating layer between the people and the corporation attempting to put something in so that the agency becomes an interference level between the two. And so people come to us and they say, well, the regulatory system, we need to fix it, it's broken. To which we say, no, maybe it's working perfectly. Maybe it's working just the way it was intended. So we gave up hope on the state and federal level of government just because they're so intertwined with the corporate stuff. And in some ways, they're all part of the same corporate state kind of thing. The endless production of more stuff. I mean, that's kind of the underlying value that drives everything. And so we decided to switch gears and said to ourselves, okay, if the state and federal government is out of our reach, we don't have the power, we don't have the force necessary to make those things work for us, then maybe municipal governments, these sub-state governments, the counties, the towns, the villages, the townships, the places where we live, surely we have authority within those communities to make the kind of change that we need to make in terms of saying no to these harmful projects coming in. So we started working with those townships in rural Pennsylvania. So townships, small cities basically of 500, 1,000 people, sometimes less, 200 people, who were faced with huge factory hog farms coming into south central Pennsylvania. And long story short, the elected officials that we talked to in those early days, and we said, well, you guys need to do something here because the state and federal government's not going to help you. There's nobody that's going to help you do what you need to do to stop these things coming in. That the elected officials said, well, no, we can't ban X, Y, and Z here. We can't ban those factory farms here. That would be illegal to ban those factory farms coming in. And that was our first, up close and personal look at the rebar and the concrete about how the system is actually built. Because we look back at those elected officials and said, what do you mean? What do you mean when you say it's illegal to ban something at the local level? So we had to come to grips with the fact of the structure of law being in place. It's not that we sat back in an academic sense and said, oh, it's there and let's explore its basic parts. We had to run up against it individually in each of the places where we work. And so these community groups in those municipalities, just like East Boulder, County United, and the community groups that you have here that have been trying to use their elected officials and their municipal governments to move forward, started contacting us and asking us some really difficult questions, which basically shook our core all the way down. And it took, again, 15 years for us to go through the various processes and learn how the system works, apart from the myth of how we think it works. But the people calling us were no longer willing just for us to say, the system of law bans you from prohibiting legal uses in your community. They wanted to know why, right? Where does it come from? Why is it there? And so the first set of responses we had to them were fairly easy, which was we said, well, if you attempt to pass a one-paragraph ordinance, so let's say the city of Longmont passed a one-paragraph ordinance that banned all fracking within the community of Longmont. The first thing that would happen, as has happened in these different places, is that the corporations affected by the one-paragraph ordinance, they sue. They sue the municipality that passed the law. And they sue the municipality for violating the corporation's constitutional rights, right? It's usually the first claim in these lawsuits. And we've seen 50 of these things. They're all the same. The joke is we could go to work for the companies and boilerplate the thing on our computers because we've seen it so much. It's a script, okay? So keep in mind, a lot of our job is about seeing patterns. So you hear the story about what happened in Lafayette and some of these other places, but it's all a pattern. It's about seeing those patterns to understand that it's structural. It's not just one place, it's not just one elected official, it's not just one bad apple, it's none of those things. It's actually that pattern or structure. And so people would say, well, why can't we just pass a one-paragraph ban on factory farms? And the answer is because you get sued, and the corporation comes in the door and they say, we are a corporation, we are a person under the law. So this concept, if people have heard of corporate personhood, that corporations are legal persons underneath the US Constitution. This gets a little complex here, but you and I have Bill of Rights protections. We have free speech rights. We have a right against warrantless search and seizure. We have all these things guaranteed to us or secured to us by the Bill of Rights of the US Constitution. Well, back in the 1800s, corporations succeeded in getting the courts to say that corporations were persons too. So that corporations have those First Amendment rights and those Fourth Amendment rights and those Fifth Amendment rights. Why does it matter in this context? It matters in this context because the permit held by the corporation is property under the law. It's something that can be owned, sold, bought, bartered, transferred, whatever. It's actually property under the law. Why does that matter? The Fifth Amendment forbids government from taking property without compensation. Okay? So that permit, which may look like just a piece of paper with ink on it, is actually a piece of property that can be sold. It's like your deed. You transfer your deed. It's a piece of property. It represents that property. That property, when a local government passes a law that forbids the activity that is authorized by that permit, it's a takings of the corporation's property in violation of the Fifth Amendment to the US Constitution, okay? So it's a little complex. And so corporations, when they come in the door to sue your municipalities, when they pass this one-paragraph ordinance on banning whatever, the first claim you see is the corporation's asserting its corporate rights. That's one of the rebars in the concrete about how this system is built, is that corporations have certain rights. In addition to Bill of Rights protections, they have Commerce Clause protections. They're protected in their engaging of commerce under the Constitution, so they can also bring that claim against the municipality. In addition to that, dear to everyone's heart here is something called preemption, which is that corporations sue saying that the local government can't pass and couldn't pass the law that they passed because they're preempted by state or federal law. That means that there's a state or federal law that nullifies the local law because it does not give authority to the municipality to pass the law in the first place. Here, you have the Colorado Oil and Gas Act, which preempts any municipality from banning fracking and oil and gas extraction within the municipality. What's great about coming to Colorado is that in other states I have to prove that somehow. I have to go through, the last 20 years about how the courts have ruled and what the interpretations are. You guys have real-time examples because the Colorado Supreme Court has overturned Longmont and Lafayette and the other communities that have attempted to ban fracking and oil and gas extraction within their community. I don't have to prove it to you. Just read the court decisions. You don't have to trust me, just read the judges, right? Read the decisions about why preemption clears away your authority to actually ban oil and gas extraction. And the third concept that comes into play is something called Dillon's Rule. It's the concept that municipalities, your town, county, village, township, whatever, only has the legislative power specifically given to it by the state legislature. That otherwise you have zero inherent lawmaking authority as a municipality unless it's given to you specifically by the state government. So in these cases, when you're watching the lawsuits come in, the first claim is corporate rights, you're violating the corporation's constitutional rights. The second claim is you're violating preemptive law because you don't have the power to pass what you're passing. And the third claim is Dillon's Rule, which says you don't have the authority in the first place to pass what you've passed within the municipality. Those are the three claims that come in the door. Any fourth grader, any second year law student could draft the same complaint, mimeograph it. We don't have mimeograph machines anymore, but mimeograph it off. I use it because you got the mental picture of just like churning them out. That's what the lawyers do in these firms for the corporations. They just churn them out. It's nothing personal. They just churn them out because all they have to do is punch the buttons. The buttons have been built over the past 200 years to actually just punch the buttons and get the result, right? We don't have the same buttons to push because they've been taken away from us over the past 150 years. But those are the buttons that they push to sue these places. And it gets worse, which is that under a post-Civil War law, known as Section 1983, doesn't matter the number, but that corporations can sue your municipalities not only to overturn the law that's been passed, but to sue you for damages in the form of future lost profits. So in other words, as a municipal official, you're thinking nothing ventured, nothing gained. I just passed this ordinance. If we get sued, we have a municipal solicitor, we have insurance, we'll cover the cost, and the worst case scenario is it gets overturned. No. The worst case scenario is that the corporation sues you for $4 million for the loss of the gas resource that they can't access as a result of the law that you've passed, right? That's 1983, and it works in conjunction with the violation of the corporation's constitutional rights. So if the Constitution's civil rights are violated, it gives them automatic access to that statute, which allows them to recover financial damages from the municipality. And that's connected to another statute, which allows them to recover attorney's fees against the municipality. So if your community passes something, you're not just looking at having something overturned by the judge. You're also looking at a potential damage award against the municipality for the damage caused for not being able to access the resource. But you're also looking at a bill for attorney's fees to pay the lawyers for the corporation to sue you. To pay the corporation's lawyers to sue you, right? So talk about debt shifting, right? It's all about risk shifting and debt shifting onto those least able to do anything about it, which is our municipalities, our communities. And so these phone calls that came in would say, why can't we? And we'd explain why they can't. And on the corporate rights stuff, they'd say, why? Why do corporations have these constitutional rights, right? And we'd say, we're so happy you asked, because we know the answer to that one. And the answer is that back in the 1800s, the courts began giving corporations constitutional rights. So it happened very slowly in the beginning. It was just something called the Contracts Clause. then it became the First Amendment, then the Fourth Amendment. People may have heard of the Hobby Lobby decision, which recognized that corporations can have religious beliefs under the Constitution. You've heard of the Citizens United decision, which struck down campaign finance legislation on the basis of corporate First Amendment free speech rights. In other words, this isn't some romantic, abstract thing that corporations have corporate personhood rights. They're actually used. It's where the rubber hits the road. And the rubber hits the road most of the time, the majority of the time, on you. You become the road. They're the rubber. And that's where it hits, is when these things come into play. So we would say, well, corporate rights go back to the 1800s, and courts gave corporations constitutional rights. And the folks on the other end of the line would say, why? Why do corporations have constitutional rights, right? And we would say, well, it's because we operate within a U.S. constitutional structure that's about elevating the rights of property and commerce above the rights of people, communities, and nature. That the U.S. Constitution, leaving aside the Bill of Rights, which, by the way, had to be driven in by a revolt, by folks refusing to ratify the Constitution without a Bill of Rights. So the text of the U.S. Constitution is very clear. It's about elevating certain rights over others. And if corporations, which became the dominant actors in property and commerce after the Civil War especially, became those dominant actors, it makes no sense to protect certain rights and values in the text, but not confer those rights and values on the corporations themselves, who are the predominant actors in carrying out those property and commerce activities under the Constitution. So we would talk to folks in the community about that, and they would say, why? Why does the U.S. Constitution protect property and commerce? And we'd say, well, we'll take a stab at it. We don't really know why, but here's our thoughts on that, which is that the U.S. Constitution was written in the 1780s. And the 1780s, the mindset by the founding fathers was that we had resources that needed to be exploited across the land, that to become a powerful nation and not continually invaded by England, re the War of 1812 and everything that happened afterwards, that to become a powerful enough nation, both economically and defensively and to protect ourselves and everything else, that we had this massive amount of raw materials that needed to be exploited and made into usable items of commerce. And so they wrote a constitutional structure that did exactly that. It's worked very well from that mindset. They didn't know anything about ocean acidification or frack well leaks through concrete casing or endangered species or climate change. They didn't know any of those things. We have a 1780s DNA. The DNA, the constitutional DNA of this country, is from the 18th century, right? The text of it, the structural stuff of it. And it's not open to communities having authority to protect themselves against dangerous things that come into those communities. So we would say to the folks on the other end of the line, right? And if they hadn't hung up yet, they would say, well, why is that? Why does the Constitution embody those values? And we said, well, it's because the U.S. Constitution borrowed stuff from English common law. English common law, which developed in the worst part of the colonization era of the world, where England and Portugal and France and the other colonizing nations were going into the Caribbean and basically superseding their structures of culture and law with England's, and about England taking a structure of law and superseding it onto those places. That's where English common law came from. It was about violence, it was about racism, it was about all the bad, really bad stuff. But our lawyers who gave birth to the Constitution, who wrote the Constitution, they thought English common law was the best thing since sliced bread. So if you read the Constitutional Convention and Alexander Hamilton stands up and he says, we know, everyone in this room knows that England has the best source of law ever invented on the globe. I mean, those are the kind of speeches that were being given in constitutional halls. They were drafting the Constitution, right? And so people on the other line would say, well, why is that? Why do we borrow English common law? We say, we have no idea, right? I mean, that's about as far back as we go. But all to say is that the stuff that you see today is like the iceberg. And the rule on the iceberg is that 20% of it's above the water and 80% of it is below. And our activism sometimes only sees the 20%. And we say, oh, all we have to do is elect somebody new, somebody good. just need to elect somebody good to the city council and everything will change. Or we just need to appeal this permit in a creative way. Or we just need to tweak the regulations to make them better. Or we need to make it so, this is my favorite one, we need to make it so expensive that nobody comes in here, right? Well, don't you think that corporations thought of that? In fact, they thought of that 80 years ago. And there's a line of cases where if you make it too expensive, it's treated by the courts as a ban, because that's what it is. And you get the exact same lawsuit. And the lawsuit says you're violating our corporate rights and you're preempted and there's Dillon's rule. I mean, how stupid are we, right? I mean, in some ways. We've been trained to be stupid in some ways. But the key is to understand that it's what you don't see that kills you, right? It's what you don't see. And it's also not what the corporations are doing illegally. That's the problem. It's what the corporations are doing legally. That's the problem, right? And that puts us sometimes in a completely new and different brain space. So it's still amazing to me, I'm going to finish up here because doing a lot of talking. It's still strange to me that what started in rural Pennsylvania, in a little community of 500 people, 500 people in a community who stood up and said, fuck you to the factory farm corporations coming into South Central Pennsylvania, said, we don't care that we're going to get sued. We don't care that you're going to bankrupt our community, right? We know that there's no other option. We know that the other doors are closed. We know if we work through the regulatory structure, we're going to get a better factory farm, right? A factory farm with less fly swarms, right? That's some of the conversation that was happening in the environmental groups when we came in 15 years ago. You know, do we just need to limit the odor and the fly swarms and everything will be okay? Well, it's not okay. When you put in a factory farm, you're eliminating family farmers because you're putting in a corporate structure of farming. And we've lost 300,000 farmers in the last 20 years. And you know, you could go on and on with these statistics about what the actual problem is. The problem with, you know, frack wells is not air pollution and the other things that come from it. It's the fact that you're taking shit out of the ground and you're combusting it, which eventually is cooking the planet. That's the problem, right? That's the problem that you can't fix. You can throw however much money you want at that problem. You can't fix it. Air pollution, those types of things, corporations can fix those. I mean, they can put money in it to fix those. So anyway, what Cliff outlined here, what's happened in this trajectory, is the exact identical experience of other places. And the only other story I want to tell here, because I think it has direct relevance to what you guys are doing, is Spokane, which has been my home for the past 5 years. And in Spokane, Washington, folks came together and said we have to do something about the coal and oil trains coming through the city. Spokane is situated in a place where all the coal coming out of the Powder River Basin, all the coal moving to the West Coast, comes through one bridge in the city of Spokane. One bridge, right? And people in Spokane said, basically, if we don't take steps to stop that coal and oil coming through, we are co-conspirators to the whole thing. We are basically involuntary or voluntary by silence. Our silence is assent, that we are co-conspirators to this climate change catastrophe that we are now well underway on. And so they decided to draft a climate bill of rights, which was modeled after Lafayette's bill, the legislative measure that was championed by Cliff's mother on the Lafayette City Council. We took that, modeled it as a template, and sent it to the City Council of Spokane. The City Council of Spokane voted to put it on the ballot directly. They looked at it and said, this makes a lot of sense. It had the direct action stuff in it that's become so controversial here, that in essence, that if the city didn't enforce the law, that direct action could be used by people within the city to directly enforce the law without fear of law enforcement coming in and arresting them. What the law did was ban fossil fuel shipments as a violation of the right to climate. People have a right to climate, and the ban on fossil fuel shipments was necessary to that right. City Council looked at it, not particularly the most progressive City Council, and voted to put it directly on the ballot. The railroad companies then put pressure on the council and said, we're going to sue you if you allow this to go on the ballot. And we're going to sue you because you're interfering with, guess what, our corporate rights. You're preempted by the Interstate Commerce Commission Termination Act, the ICCTA, which is the federal law that takes all local authority away from regulation over the railroads. And Dillon's rule kicks in because you don't have authority as a municipality to pass this in the first place because the state legislature has never given it to you. President of the City Council the main leading liberal Democrat in the city of Spokane stands up and gives a speech that we need to take it off the ballot because we can't risk a lawsuit from the railroad corporations. Gets enough of the liberal Democrats to go along with them, they take it off the ballot. The next step was the people, us, who proposed it in the first place, have now taken it, converted it into an initiative. The petitions were printed 3 weeks ago, and now we're moving to qualify the initiative directly through the citizens process. Last time we did that in Spokane, Chamber of Commerce and the corporations there sued to keep the initiative off because now there's a huge new area of, believe it or not, pre-election ballot challenge litigation in which corporations are taking stuff off the ballot preemptively before it even gets to a vote because they understand how dangerous it is once you vote on it. Because once you vote on it and approve it, they have to go to court to nullify it, but if they can kill it before it even gets to the ballot box, that's the direction that they're heading. In Colorado, that case law is starting to build. It's not as bad as other places, but it's headed in that direction. And so in Spokane, understanding that the legislative stuff was limited as well, a group was created called Direct Action Spokane. And last year, they had the first 9 people arrested on the tracks. Successive groups of 3 people who actually stopped the railroad traffic for about 5.5 hours coming through the city of Spokane. They're going to trial in April and May. But all to say, people in Spokane and other communities, and we work with about 300 communities across a 20-state region now, including some of the tribal nations who are beginning to contact us because they have greater leeway of lawmaking, not much, but a little greater leeway of lawmaking than the municipal governments that we've been working with over the years. That those places are all feeling the same thing that you're feeling and understand that we are to a point where we have exhausted all imagined remedies. That in our heads, we think we live in a democracy. And in a democracy, there's a remedy for every harm that gets caused. It's been inculcated in us since kindergarten that we live in a democracy and there must be some avenue of legal change that we can make to stop what's threatening to harm us. But in reality, we don't live in a democracy. It's a corporate state. It's a place in which the structure has been predetermined for us. And so we have to start coloring outside the box. And part of this Lafayette piece of legislation about the direct action civil disobedience was about doing just that, which was moving outside the box and understanding that our activism needs to be commensurate with the problems that we face today. And our activism today, especially in liberal circles, is not. And in fact, I'll leave with this thought, which is we refuse to work with conventional environmental groups anymore. We work with the grassroots environmental organizations, but the big environmental groups are just as bad as the corporations that we try to stop in our communities because people think of them as allies, when in reality they're sending people down the regulatory chute. They're going down the better regulation, they're getting down the permit appeal stuff, and they're actually removing the ability of communities to move on their own. What we think needs to happen is a revolution of 10,000 communities who stand up and say, screw you, we're not doing this anymore, and we're going to build a new system of law. And in support of that, we've put together a legal doctrine, the right of local community self-government. We submitted a law review article to give it some gravitas, but eventually it says you have a right within your community to expand civil and political and environmental rights out at the community level above and beyond what the state and federal constitutions provide. And that may sound radical at first because we can't get our brains around local bills of rights. In other words, we don't necessarily think of our cities, towns, villages, and counties in that manner. But it's actually not radical at all because for the past 70 years, the courts in the United States have recognized that state governments can expand political, civil, and environmental rights out beyond the federal minimum. So the federal Bill of Rights is a floor, and states can build on top of that floor. What we're arguing in the courts and also in the constitutional amendment processes, which are moving in several states, is that we need to take that same relationship and apply it to the local versus the state and the federal. That local can expand out civil, political, and environmental rights above those offered by the state and federal floor. And that's where we're headed. But we don't have faith that the courts are actually going to embrace that anytime soon. And so we're working with other state networks like the Colorado Community Rights Network to move forward state constitutional amendments, which would actually change the constitutional structure of law to get at some of these rebars that have been set in the concrete for the last 150 years, which stop you and stop me and other people in other communities from stopping that which threatens to harm them. So that's where we sit.
Okay. The question is examples of environmental organizations that are colluding with this corporate state.
I have two good ones that are short. One of our clients is the city of Pittsburgh, or was the city of Pittsburgh, when they became the first major municipality to ban oil and gas drilling within the city. And we had all the council members lined up. There were 9 of them. It was not an easy task. It took us 5 months to get folks to that place. So it was a community bill of rights that banned oil and gas drilling and recognized nature as having rights within the city of Pittsburgh. Had a unanimous city council, and the night before, the state's largest environmental organization called Penn Future sent a letter to the city council urging them not to pass it, saying that they would get sued and this wasn't the proper way to work, that the proper way to work was through permits and through other challenges and stuff like that. So that was a real life example. And the second one was, we didn't talk today about rights of nature stuff just because that takes a while, but this concept that ecosystems shouldn't be property, but should have rights of their own, independent rights of their own. That's kind of a new concept that's starting to gain traction, and the Ecuadorians called us in to help them write the new Ecuadorian constitution, the national one, which got ratified. Now we have some cases that flowed from that. I thought perhaps it was specific to the United States about these environmental groups, but it's not, because we had the votes lined up. Well, we didn't line them up. It was the indigenous organization there in Kanai, had lined up the votes to pass the rights of nature into the Ecuadorian constitution. So it became the first country to switch from a property-based system of environmental protection to a rights-based system of environmental protection. This huge paradigm shift that everybody's always talking about but rarely happens. And at midnight the night before, we get called into a room with the World Wildlife Fund and other big NGO organizations in Ecuador to try to convince us to drop it. And I was floored, and that I think was my last straw. That's why they're as big a problem as anybody.
Real quick, there's plenty of organizations here in Colorado, and they really act as kind of front groups for the Democratic Party. One of them is the Logic. Has anybody heard of Logic? So this is the League of Oil and Gas Impacted Communities. There's some big name celebrities on it, like Deb Gardner, Elise Jones. How many people know Jared Polis? And I took a quote from the front page of their website because Christine Berg, who is the mayor of Lafayette, was speaking out against the direct action component. And she was saying that she was speaking against it as an environmentalist. And this is a featured quote on their website. It was from a person in Adams County. It says, "Together with Logic, we can pass new energy policies that prioritize public health and safety, protect homes and schools, and still allow for responsible oil and gas development." So this goes, if you do searches on this, Conservation Colorado, if you watch guys remember when Jared Polis pulled those ballot initiatives for the governor's task force? The person standing behind him was Pete Mayhack, I believe is his name, from Conservation Colorado. So Conservation Colorado, Environment Colorado, they all work within the same they're kind of colleagues with this kind of stuff. And they kind of flank us usually with that kind of language, with this idea that, they go after our legitimacy. Well, these guys are, we would all love to ban fracking, but it's so radical, let's all be reasonable. To be quite honest, and I'll say this bluntly, the environmental organizations of Colorado have cost me more sleep than the Colorado Oil and Gas Association. It's something that we have to that has to be overcome. It's not really something that we can work alongside. I mean, we all want to work alongside of everybody. But in Lafayette, those were the dominant voices that came out against the Community Bill of Rights and also the Climate Bill of Rights and Protections.
At one point in Pennsylvania, we had a group that was dedicated exclusively to fence height around frac wells. At the state level, that's all they worked on, was how tall the fences should be around the frac wells. So there's a bunch of stuff wrapped into what you just asked. I think 4 different questions. But on the first one, why run the ballot initiatives? I think the 2 reasons that you identified are the 2 reasons. One is it's education, because the ballot initiatives take aim at those rebar concepts. They basically nullify corporate rights, certain corporate rights within the community. They nullify preemption when preemption is done for certain reasons. and they automatically expel Dillon's rule because they start out with a right of local community self-government, that we have an inherent right of local community self-government. So those community bill of rights are about essentially people asking, why are we running this? And then opening up the space to have a conversation about why you need to run it in a certain way. On the second point, I'm a lawyer, so I wear the lawyer's hat, and when we go into court, we try to win. Unbeknownst to many people, I've found, is that last year in November in Oregon, a federal judge in district court, U.S. District Court, held that a constitutional right to climate exists. Okay? Judge Ann Aiken in the U.S. District Court was in a case brought by Our Children's Trust, which is a group that brings litigation on behalf of young people to say that you're screwing us 7 generations down the road, or you're screwing our legacy, and brought a case against the federal government saying that you need to be doing X, Y, and Z to stop climate change or to mitigate it, regulate it. And the federal government brought a motion to dismiss, said you got to throw this out, there's no claim because there is no right to climate, and the judge held that there is a right to a healthy, livable climate. It's the first time ever, and put that right on a level with due process and equal protection, right to privacy, I mean, all the big fundamental constitutional rights. So the idea is, can we leverage that, even though Colorado's not in Oregon's jurisdiction, but it gives you another platform to basically, if you draft it around that decision, to use that to argue to other judges that a right to climate exists, because, especially because the judge has found that it does. So it gives you a little bit more credibility, a little bit more advantage. Having said that, we don't put our faith in the courts, because the courts invented corporate personhood. They invented preemption, believe it or not. Preemption is a judicially derived doctrine, and Dillon's rule flows from preemption. And so we're in a position where that's why we two-pronged approach, which is that we believe textual change of state constitutions and eventually the federal constitution is necessary. So in Ohio, in Oregon, in Pennsylvania, in New Hampshire, Colorado, folks have not only designed these constitutional amendments that can be used to change the state constitution to eliminate corporate rights and Dillon's rule and preemption to some extent, that those are being driven in by people. So in a lot of places you have what you have in Colorado, which is citizens' initiative to change the Constitution. In other places you don't, like New Hampshire, where it's been introduced by Democrats and Republicans to change the Constitution. In other words, you don't want to put all your bets on the courts acting, because the courts take forever to act and usually they come last. So we don't choose when we go into court. The other side sues us, so we have to have a doctrine that argues to the judge that under conventional law you can maneuver through it this way. But at the same time, we're working on a different level, which says the courts will never do that. We need to move in a separate direction to textually change those constitutions. On the other question about corporate rights, couldn't agree more. The problem is that the law privileges a certain few people. You know, the homeless don't incorporate, right? The homeless don't have corporations. So you have a certain privileged few who use the corporation as a boxing glove. They put the boxing glove on, then they beat the shit out of the communities. That's what they do. But the boxing glove is created by the state. It's created by government. So it's not just that you have private corporations. The private corporations aren't really private, because as soon as they're born, as soon as they're created via charter by the state, they automatically accumulate these massive amounts of rights. So on the date of incorporation, they automatically become a federal person, they become a state person. One of the things that we've explored in the past, but these talks aren't long enough to get into, is that your Colorado state constitution, judges have held that corporations are persons under that. So even if you chase them out of the federal constitution, they still have constitutional rights at the state level. But the key is to understand that when what you're looking at is a problem not of corporations, it's not a corporate problem, it's a government problem, it's a state problem. It's a structural problem in that respect, because the corporation couldn't do what it is going to do to you unless the state has given it certain powers to be able to do that. And so a lot of people always talk about, well, it's a bad corporation or a good corporation. It doesn't matter, because as a corporation, you acquire those different rights that by virtue of your wealth, you're able to drive. So you and I have the same rights, First Amendment, Fourth Amendment, whatever, but we don't have the wealth to drive them. It's a combination of that wealth disparity with the rights that creates the perfect storm which then allows them to come in and override.
Well, here's the crux of the whole matter, and I'll try to answer this as briefly as possible. But one of the initial mistakes that we always make is that we look for the system to fix itself. And so we say, well, let's come up with a nice talking point or a good legal argument by which the system will then eviscerate its own oxygen. It doesn't make any sense. So what is interesting to me, though, is that we've become so alienated from prior movements that we've suffered from this loser mentality now, where we don't say, what is it like to win? We say, how can we lose in the most comfortable way? And it's a real problem, because movements are not without risk, right? It's easier to get a lawyer and go to court, or maybe send a letter to your city councilor or something like that, because it's risk-free. You don't have to risk anything. And we've been so long without a legitimate social movement that we don't understand anymore that if we all take the risk at the same time, the system will collapse. It will collapse, because right now it's relying upon our complacency and our cooperation. And it gets through a lot of different ways. For one, it gets that through saying, well, the city councilor said she was an environmentalist, so she must be an environmentalist, so I'm going to go along with her, right? Or it gets it, well, if you step out of line, I'm going to hit you with a baton, right? But it gets our cooperation one way or another, and we have to stop thinking like that. So with Boulder County, where we've got 1,800 wells now imminent, right? And what the commissioners are telling us to do is to cooperate in the destruction of our own environment at the cost of our own lives. Those types of dynamics have got to be erased. Why do we run things like the Climate Bill of Rights and Protections? Is because people do not see the conflict. The conflict is latent right now. It exists. We've got a system that's asking us to compromise our very lives at this point, and we're all supposed to shuffle along with it. When we do things that are off of that script, it exposes the contradictions that the system is asking us to walk around with. I mean, right now, after the Lafayette City Council meeting, somebody said, well, the mayor is still our friend because she's an environmentalist. And I said, the mayor just told you that if you fight against the oil and gas industry, she's going to have your ass arrested. So when the contradictions within society become so great, at some point, and we have to continually point to those contradictions, because we have to take it upon ourselves to make them impossible to live with, right? When the Boulder County Commissioners say, well, we'll put a setback of 750 feet from the nearest school, and you say, well, that guarantees the drilling. I mean, maybe you'll put it next to a church, or maybe somebody else's neighborhood. We have to expose those contradictions. Any movement in history, and everything gets called a fucking movement these days. They're not movements. They're political actions. A movement is when a group of people understands that the system is corrupt itself and goes about conscientiously violating the laws of that system with the intent of breaking them, right? Rosa Parks did not get on the bus that day to get a nicer seat in the segregated part of the bus, right? The abolitionists did not say, well, we're going to regulate the amount of lashes the slaves are going to get, right? These are non-starters, right? The labor movement did not say, well, we're going to go ahead and ask for the 8-hour workday, but the only way we're going to go about it is signing a petition, right? So we have to sit with the idea that if we're going to save our planet, everybody in this room and everybody outside of this room, we're going to have to start taking some real risk.
A small percentage, it's only like 5 or 10% of the people have to resist. And that's a critical mass.
Right. We have to convince the people that they need to resist to begin with, right? In Lafayette, when we first started this, people didn't really think fracking was necessarily all that bad. They didn't even know that it was possible there. So what we've found in Boulder County is that the only things that have won is when we have removed our cooperation with the bullshit, excuse my French, that we're being force-fed all the time, and started to build our own grassroots political force. At that point, things start to change. The narrative of clean burning Grid fuel, nobody uses that anymore. And the reason is because you've had a critical amount of people that have now made that idea poisonous to anyone trying to shovel it off on us. 5 years ago, when we were fighting fracking, the regulatory stuff was accepted. It was fully accepted by people. If you went to the county commissioners meeting this last week, people want to ban fracking. So the first thing that has to give is the mental constraints that we're handed. And the way we do that is by demonstrating disobedience. I don't know how else to say it. But we've said, I mean, the way we're looking at it, and I'll shut up after this is the basis on which we're organizing. And we couldn't have done this if we cooperated with all of the expectations of the environmental groups and the law system and all of our politicians before. If we didn't go about creating a community bill of rights that intentionally broke the law that was keeping us constrained, we couldn't have spoken like this. But this is the way East Boulder County United is operating now. We've got 5 points. One of them says we have spoken clearly on the issue of oil and gas development, and it is resolved that we do not want drilling in Boulder County under any circumstances. It is a violation of the land, our health, and our families, and the well-being of our communities and climate. 2, any attempt to forcefully move fracking into Boulder County is a violation of our fundamental rights. 3, the laws that seek to remove us from protecting the land, the local environment, the climate, and our right to self-govern are in every way immoral and illegitimate. 4, we have the right and obligation to protect the environment, our families, and our communities. And 5, all government officials are being asked to side with the people in every capacity, refuse to administer the destruction of the land and its climate, and enforce the will of the community to protect ourselves from any intrusive industry that fails to recognize these fundamental rights. Right? So how does that actually manifest or look in Boulder County? If the county commissioners make any attempt in any way for any reason to move fracking into Boulder County, we believe that it is within our right to shut that process down physically, right? If they bring it into permit hearings in the land use department, we believe that that is a violation or a preparation for the violation of our rights, and we will shut those things down. By the way, Tom is holding a real empty jar here, and we need legal defense funds because we imagine that as a component to these campaigns to creating this independent political force, we are going to employ direct action, and there are going to be people that are arrested probably in the next month or two, is our trajectory. We need funds for that. We need funds to levy the campaign. We, of course, are going to ask you for as much money as you can spare. We're risking our freedom. Kick in $10.